Hello, everyone. We're just going to give it another minute or two and let everybody hop on, and then we'll get started. For those just joining us, we're gonna give it about 1 or 2 more minutes. Okay. Hello, everyone. My name is Paige Murata, and on behalf of USLAW Network, we welcome you to this USLAW Remote Learn webinar. USLAW Remote is a series of virtual offerings ranging from our brand new podcast to roundtables and more. If you'd like to learn more about these offerings, please see the link that I'm about to post in the chat. Today's webinar topic is your company secretly wiretapping private conversations? Since this session is set up as a webinar, your microphone and camera are turned off, but you can use the Q&A feature to post any questions and comments, and our panelists will do their best to answer them as they come in. Now I will turn it over to our 3 member attorneys and allow them to introduce themselves.
Good afternoon, everyone. My name is Molly Arranz. I am the chair of Amundsen Davis's data privacy and cybersecurity practice. I specialize not only in cybersecurity compliance and breach response, but also in advice and counsel around data privacy and consumer privacy requisites. I have my certification in information privacy as well. I'll turn it over to James and Karen for their introductions.
Perfect. I'm James Snyder. I chair the transactional practice group for Klinedinst, based in San Diego, California, as well as the data privacy and security incident response team for the firm. I think you might be on mute, Karen. There you go.
Karen, you're on mute.
That really helps. You never mute a woman, that's for sure. I'm Karen Randall. I'm a partner and chair of cybersecurity, data privacy, and incident response at Connell Foley. We're expanding into AI governance as well, which is going to be hopefully part of this conversation. We'll find it somewhere, right, Molly and,
Yes.
and James? But happy to be here and looking forward to the discussion.
Great. So we're talking today about a topic that isn't potentially on your radar, and certainly not a topic that in my mind would be falling under traditional cybersecurity and even data privacy topics that you may otherwise go to webinars or conferences. Today, my esteemed panelists and I are diving into what could be considered more of a consumer privacy issue. In my mind, it melds very well with data privacy, and it's certainly a hot topic, as you'll find out today. Any company that has a business to consumer B2C presence, so any company that has a website, this topic will affect you in some way, undoubtedly. A word of warning, we're going to be talking through data privacy. James, Karen, and I have talked about the fact that oftentimes when we're talking to companies about data privacy or cybersecurity, we're being put in touch with the IT department. But as you'll quickly learn today, you should be having this conversation with your marketing director or chair, or certainly any vendors that you would be utilizing outside of the company for marketing. So the Wiretap Act, both federal and now many, if not all states, have their own Wiretap Act. Probably everybody has heard of the Wiretap Act. Any sort of CSI shows or movies that you've seen certainly touch on something like this, some dragnet type aspect of wiretapping, right? It's known as the Eavesdropping Act in some states as well. This goes back to the 1968 Federal Wiretap Act and the 1986 iteration. The idea was we didn't want the government, or frankly, private institutions or corporations, to intercept or eavesdrop our private conversations. Or having a phone call with your mother, they're tapping into it to see if you're talking about any sort of deep state issues or any sort of conspiracies against the federal government or the state government. This led to, concerns over warrants and seizures of that information. It also led to, and this will be something that you will hear a lot about today, consent. We want some level of consent to know that we are being eavesdropped upon, certainly if it's by a private company or institution. And to bypass that, obviously, we know the federal government, the police, et cetera, the FBI may bypass that by secret warrants. But that's not what we're talking about today. We're talking about private interception of, or what would be considered eavesdropping of, conversations. Fast forward to today. These sort of what could be considered maybe antiquated laws are being used and at the cornerstone of creative lawyering, frankly, against companies about their use of tracking technologies, cookies, pixels, certain Google Analytics, various tracking technologies that companies are using on their websites, and they may not even know it, to collect what used to be considered, in my mind at least, and I think in Karen and James's mind, de-identified data points. I'm clicking on certain things on your website. I'm searching for certain things on your website. I'm being led to go to Instagram or Facebook or other LinkedIn type websites after I've seen ads or I found out more about you, right? These seem to be de-identified, anonymized data points, but now, given the world of technology and how fast it's progressing, is being used instead as a factual background for claims against companies about illegal wiretapping and eavesdropping on people's back and forth with companies. So what we're finding is that, like I said, any company in my mind that's consumer facing, has a website, should be concerned about this. Whether it's legally sort of allowed or a basis in terms of transparency, consumer expectations these days is that there's almost full transparency around what companies are collecting data points. For instance, and James, I know you brought this up yesterday, right? We know that California has the California Consumer Privacy Act. Other states are following that lead about what you need to put on a privacy policy, for example, as to the collection of information about individuals, their names, their addresses, obviously any gender, racial, cultural sort of background about them. All these sorts of data points that you need to put on a privacy policy to explain to consumers, private individuals, about what you're collecting. This is, I think, a bridge beyond that. And so, James, I think, Lisa, you were bringing this up yesterday in terms of your experience around CCPA, and you're in California. Can you give us a sense sort of like top of mind for businesses, separate and apart from this, and maybe how this would sort of interface with those concerns around the CCPA and otherwise?
Sure. I think at the end of the day, the two are married for better or worse at this stage. And to your point about creative lawyering, plaintiffs' bars are certainly not just tacking this on. In some cases, they are throwing the kitchen sink, if you will. But in other cases, it's purely a wiretap attack, if you will, for various reasons, private rights of action, et cetera, we kind of talked about. So to me, I think it's just best practices for businesses that this might be applicable to ensure that their privacy policy is robust. They understand what data they have, where it is, how it's being used, not just from themselves, but with their vendors as well. And that they build in, probably most easily, into a cookie policy, whether it's a locally stored object or a pixel, which isn't stored necessarily locally, they build it in. And the key, as I'm sure you're going to get to, is making sure that folks are consenting to the actual use and collection before it takes place. And that's the crux of the main issue to me.
I think that's the key issue, James and Molly, and I think Molly mentioned it earlier. There are a lot of businesses out there that hand over the technology and its use to certain people without having any type of human oversight. They don't, it's an IT issue. They'll handle it. Or, marketing has a website up. I really don't know how it operates, whether or not we're collecting any information, whether or not they're using tracking technology. 5-10 years ago, none of us
Right.
really that concerned about it. We weren't asking those questions, but this landscape has evolved so quickly. Any business has an obligation to understand the risk and benefits of the technology that they use. They apply the RPCs to attorneys, right? In order to be competent, you have to understand the risk and benefits. But that really applies to everyone. So for anyone on this call or on this webinar today, when it's over with, and we'll have best practices at the end, but make a note to talk to marketing. You're right, Molly, that's not where you start. Talk to your IT. That's not where you start. It's again that holistic approach, understanding how you work, what you use. Have you made a decision on how you want to use it? Talk to your compliance officer, legal. You have to understand the privacy laws, even the security laws that apply to the collection anonymously, supposedly, even though it is connected to a name later on, so that you can properly protect yourself against risk. And hopefully, maybe, we talked about this yesterday, Molly and James, transferred to a policy of insurance, but we all kind of scratched our heads on that and said, interesting, for these tracking suits, what type of policy would provide you with the coverage? We're not asking for an answer today from you all, but you better get on the phone with your broker and find out, because we're seeing a lot of lawsuits.
Yeah, and to that point, so it has some stats here. In 2023, the top 10 privacy settlements totaled 1.32 billion with a B, in terms of what these sorts of exposures could be, right? This jumped to over 2 billion in 2024. What are these lawsuits about, right? We're talking about sort of the tech side of it. What's the code that's embedded in your websites? What are you really tracking? Digging into the details of it, right? These lawsuits focus on the unauthorized collection of private digital data by website owners, including browsing activity, location data, and personal communications. So again, what does this look like? It can simply be the clicks. It's putting together these seemingly de-identified data points to say, well, now I didn't know it was Molly Arranz searching for best cookie dough batter on my website and seeing a pop-up of an ad that I have running on my Facebook page, right? I just know that it's a location in Chicago, Illinois, and I know that her Facebook identifier is a certain, couple of letters and numbers, and I know she searched for cookie dough, and now I'm going to push out certain ads, or I'm going to follow sort of how well that went, that sort of ad tech question that's raised. And I'm going to be able to figure out a little bit more about Molly Arranz, and maybe I don't identify her by name, but I know enough about her to be considered sort of a private information, personal information about her that could arguably fall within a lawsuit under these wiretap eavesdropping acts and related claims. So one of the things that Karen and James and I were talking about is, how do these lawsuits look, right? It's maybe not only the sort of wiretap act that may be in a given state, but it could be invasion of privacy, certain breaches of warranties or implied, breaches of contract. It could be any number of different claims that are brought. And again, it's because there's these tracking technologies that you may have sitting on your website. And as James was forecasting, the question is, what kind of notice, what kind of consent did you get from those individuals before you started tracking that information? Because what the argument is, and you'll see in a moment here, we've got some sound bites from attorneys that represent consumers that are visiting your websites, typically located in California. I know we're going to be beating up on James a bit here today about his state, but that say, my client didn't have this information ahead of time. You started to track this information. And yes, you may have this buried in your privacy policy somewhere, but I didn't get any sort of affirmative, or my client didn't get any sort of affirmative notice that you were going to be tracking this until they were already clicking around on your website. This can lead to massive class actions. Those numbers that I just put in front of you, those stats, those are dealing with exposure in lawsuits back to 2023 and 2024, and they are ongoing. Now, we're sort of Chicken Little here today, warning you about this. And like Karen said, we're going to give you some best practices and things to think about and take back to your folks, to your team. The law is by no means settled in this area, right? What we're here today is to try to give you the most buttoned up of advice, things to think about. You may get some pushback because from a business standpoint or marketing standpoint, it may push off some web traffic, right? Some potential opportunities for marketing. We're going to give you the most buttoned up of advice or thoughts around this, perspectives. But again, in no means are these settled laws. It's primarily a lot of these lawsuits actually started with class actions and claims directly against Google, Meta, Meta's Facebook, obviously Instagram, and some of these bigger data warehouses. But a question in my mind, and I know Karen and James and I all deal with this with our clients, is you don't want to have this decided by a judge in a private lawsuit or even an arbitration, right? Best to try to stave off and reduce the risk of the lawsuits in the first place. So that's what we're talking about today and the potential exposure there.
Yeah, Molly, just on that point, I think it's important to note that there are different types of trackers. James, I don't know, I don't know if you have a thought on this, but you've got your first party trackers. That's, I'm going over to Molly's website, perusing it, usually the activity ceases after I leave the website. It's not as invasive as the third party trackers. Some of these first party website, that their tech allows third party trackers to come in and get involved. They are more invasive. They're the ones that Molly was talking about earlier. You see your cookie recipes on the first party tracker technology, and suddenly for the rest of her life, and because it doesn't end automatically, she's going to get pop-ups about how she can improve her cookie recipe, and it's going to be really obnoxious. But the trackers are one thing, but the type of information that they take when you are on a website, or when these trackers are being used, the cookies, the pixels, there's the IP address scraper, they're taking some pretty sensitive information. They're taking maybe not your name, but your date of birth, where do you work, your family, what's your income. It is highly sensitive information, and quite frankly, I think we'll talk about it somewhere in this program. The question is, where is this information that has been taken as a result of my visit to the website? Where's it being stored? Is it on a database? And you all know, because you all know what we do for a living, but when there's a database with nice sensitive information and, or information that malicious actors can use, they're going to hack those databases. So it's not just privacy, it's also security issues that you're looking at. It's, is it legal? Yes, but you have to have the proper guardrails in place in order to protect yourself.
Yeah, I totally agree. And I would say in states like California with CCPA, just as an example, to me, this is already required. So In states like California, you have to tell consumers what their rights are. You have to tell them that they can ask to be forgotten. They can have their information removed. You have to give them access to whatever information you or your vendors down the chain have access and how it's being used. So even in the purely privacy context, you know, I think companies are going to fall on the sword if they're not doing this anyway. So we already have this requirement in California and other states. To me, it's a matter of, okay, best practices, let's build in these other concepts that we're starting to see pop up. And let's make sure that we're obtaining consent out of the gate. We can get more into the best practices later, but to me, these are all married, and for better or worse.
Yeah, and it's interesting to me too. And again, I think I said this before, but you know, some of it's brand too, right? Some of it's reputation. I mean, I was just having a conversation the other day with a client that we're helping with some of these, you know, challenges, and they received one of these, you know, nasty letters from an attorney representing a consumer in California. But you know, part of it is what's the consumer expectation, right? You also look like a more sophisticated, sort of on the ball, right? In my mind, you know, company, if you have some of this already in place, if you make certain disclosures, even if they're not legally required and they're measured and accurate, right? But you're showing the consumer that's visiting and considering your brand, visiting your website and considering your brand, that you're on the ball and that you have this in hand, right? And the other piece, getting back to the California privacy law, and like I said, those privacy acts are being enacted almost at a daily rate in other states. You know, if it doesn't affect you already as a company in terms of your disclosures, it's going to at some point. So, you know, better to address it today and have that peace of mind and not have to address it at a later date than to sort of wait until it hits you and then scrambling to try to get up to speed with the laws that may apply.
Yeah, and one other thing, just because you had mentioned contracts earlier, it's really a good idea because things become so outdated so quickly. So whether it's your online terms of use or service, coupled with your privacy policy, cookie policy, whatever it might be, or whether it's, you know, some sort of formal contractual framework that you've executed with a business or a consumer, it's really good practice to go back and take a look at things. Things become outdated so quickly nowadays. I mean, just the notion of confidentiality breaches having unlimited liability, for example, 10 years ago was a no-brainer. Everybody would have agreed to that, more or less. But nowadays, that could be a privacy issue, for example. So a little off topic, but I think it's important to, as the law is, you know, constantly changing, it's a good idea, good practice to go back and look at what terms are in place and how do they need to, you know, be amended to reflect the current state of risk and legal requirements.
Right. Yeah, and it's a great point because, you know, again, I have a case it's a class action. It's based upon pixel tracking technology potentially being utilized, sharing potentially with Meta. And one of the first conversations, again, after the class action complaint is filed, was a conversation with a third-party vendor, like retracing steps. Do we have this on, toggled on? Do we have it off? You know, if we have it on, what does our contract say? What are we actually sharing? Better to know that, again, and the sort of the level-headedness and the peace of mind and like, for, you know, making you sleep better at night, to have those conversations at James's point, you know, beforehand, hopefully to stave off any sort of complaint being filed in the first place, but really knowing what that sharing looks like and what those reps and warranties look like. Inappropriate, you know, shifting potential of liability, should that, you know, change over time, and how much can you shift that liability in a contractual sort of term, for example.
And part of that, Molly, I think, and James, is understanding where do you do business, right?
Yeah.
If you don't have a good understanding of that, then you're not going to be able to back into the laws and regs that apply when you work on the website and what you need to do to become compliant.
Right, yeah.
Just hope and pray you're not in California.
Yeah, exactly. The servers are located there. Right, and certainly, you know, GDPR is always kind of like a, you know, a little sparkle in the corner of these conversations too, because, you know, CCPA California followed that structure, frankly, and you know, that these are sorts of conversations around processors and controllers that were already happening hopefully for a couple of years now with those contracts and agreements. And I think it's really coming to a head here in the US as well, no matter where you're located, but
Yeah,
it's
and what
said, you know, kind of where.
absolutely, and to that point, Molly, and I'll be quick on this. If you look at sort of the precedent that is sort of unfolding in the wiretap, you know, space, it really is closer to GDPR than it is CCPA because it's requiring opt-in rather than opt-out, if you will, right? To coin, you know, GDPR's, you know, verbiage, but it's really important to sort of look at it. And we obviously this is still unfolding, and the state of law is not sort of settled necessarily here. But I think it to me it's shining a light on the fact that CCPA is a standard that is closer to GDPR, but this sort of set of you know, legal phenomenon is getting us closer in the United States probably to the European standard of requiring an opt-in rather than an opt-out. So an anecdote, but I think it's important.
Well, and I will say, you know, I was talking to somebody else on my team, you know, right before this, and that's exactly what it sounds like, right? And I think you know, we're the lawyers in the group, right? Not the folks who are dealing with your web traffic, but you know, I think one of the best practices is that sort of opt-in consent, affirmative action on a click when somebody visits your website. That's the sort of, you know, the Rolls Royce of the Cadillac of options, really, to give yourself the best, you know, safe harbor to live in. So on these next couple of slides, as I mentioned, you know, are actual quotes from letters that are being sent by these plaintiffs' attorneys or claimants' attorneys about these wiretapping, alleged wiretapping activities, right? First and foremost, you know, data has surpassed oil as the world's most valuable resource. I mean, a bit of a hyperbolic maybe statement in many people's minds, but it's certainly the mentality that's, you know, fueling a lot of the letters and complaints that are being filed. This particular letter dealt more with a LinkedIn tracking cookie or pixel, but this is the sort of verbiage you'd see. LinkedIn's tracking tools de-anonymize website visitors and send identifiable data to LinkedIn without their consent. Again, the factual background on these sorts of instances is not that it's de-identifying, you're de-identifying it by using certain clicks, and then LinkedIn is re-identifying it by those clicks and necessarily saying it's Molly Arranz and knows that it's my first and last name, right? Instead, it's being able to identify my usage with my LinkedIn profile. That then if I've been on LinkedIn or I have LinkedIn available or it's up on my web browser, that you know, if I go there, then it's able to say, hey, you were just looking at this cookie dough recipe. And now I'm going to show you some ads that maybe you would find interesting, right? It's that sort of back and forth, whether human eyes, I think Karen mentioned this, whether human eyes are actually reviewing those data points or knowing about that is a different question necessarily, but these are the sorts of claims that are being made, right? And then this is a sort of the crux of the problem, really, at least in these consumers' minds, that advertising platforms are leveraging that data to deliver hyper-targeted marketing campaigns without permission, without the awareness or consent of those visitors to your website. You know, additional sort of verbiage from these letters, right? Commercial tracker software, a tag. So you may have I know a lot of websites, I think even our firm's website maybe has a Google Tag Manager, right? You know, there's certainly a brain trust behind the sort of tracking technologies that are being used that are probably being managed either in-house or by a vendor that you're utilizing, like a tag manager. But these are tags. They're just basically tagging the activity. It's embedded, and then it captures those, you know, electronic impulses, clicks, etc., to help identify the source or the information around these individuals. And the sort of conclusion there is by installing these sorts of tracking technologies, you're letting these third parties, Meta, LinkedIn, Google, to match the user activity to the user's social profiles and otherwise. So that's a sort of threats, albeit copied and pasted probably by letter to letter and certainly complaint to complaint, but these are the sorts of like claims and threats that are being made.
And I might ask you how, I mean, I have thoughts on how you can potentially mitigate some of that risk, but I'm curious your guys. I mean, to me, to mitigate that risk, you as a company need to ensure that you have really reviewed the vendor terms and conditions in whatever format mechanically they exist, whether it's online pass-through, click-through, or some written vehicle that you've executed. Again, back to the point earlier, if it was 5 years ago, either they've been updated or they need to be. And then ultimately, how are the third parties utilizing the data? And do you know? Have you asked them, right? And I think all of those things bode well for you in the event that you get a claim, because you can at least say, we've done our diligence. Maybe you have contractual indemnification, for example, with the vendor, possibly. But all things to look at to ensure that you're protecting your own business enterprise, particularly when it's some third party that may ultimately be the crux of the concern for you.
Yeah, I think that gets us back to vendor due diligence, right? Whoever you have an agreement with across the board in the privacy and security space, who are you contracting with? What do you have in the agreement? I think, Molly, we discussed making sure that there's a waiver of all class action suits, that everything goes into arbitration, the indemnification that James was talking about, making sure that, you can audit, that they notify you if there's any complaints, but making that vendor agreement after you review it and understand it and have the right people look at it as protective as possible for you. You're going to turn to someone. It's either going to be your policy or that vendor to recover if there's a claim. So again, make sure you take that holistic approach.
Yeah, and sort of honestly at a baseline, knowing why you would have, right, this sort of like tags or pixels or cookies as part of maybe the platform that you're utilizing, right? I had a conversation the other day with somebody in a marketing department and said, hey, there's a LinkedIn, looks like there's a LinkedIn tag here. Why are we, what's the legitimate business purpose for us having that? And it was just there, right? It's out of the box, part of the offering by your vendor, James, to your point. Even before you have these conversations around shifting of potential exposure, liability, indemnification, et cetera, and knowing very well what's being collected, for example, why do we have this, right? Do we need this? Is it really critical to what our marketing or sales or business teams need for leveraging our website in an effective way? Like, why do we have it, right? I think for no matter what your disclosures are and what your consent gathering looks like, having the question around what's a legitimate business purpose for collection of this data point, be it a cookie, be it a name, be it a date of birth, it is a great place to start. Asking the why are we collecting this? And just drilling down to find out what you're collecting, why are you collecting it, right? I mean, it's required for CCPA, it's required for other state privacy laws. What's a legitimate business purpose for collecting this data point, right? And to Karen's point, I feel like we're putting nuggets throughout this presentation around best business practices, but one of the things that we would recommend, and we'll suggest at the end here, is what do your terms look like? Do you have a class action waiver? Do you have a mandatory arbitration provision? Have you disclosed that appropriately in your terms, your online terms, right? Thinking through some of those protections you can build in at the forefront here are also really helpful. So
and one more point there, just to close the loop, is, and it's really important, and I think I'm always surprised how many clients don't think of this, is if you have an online set of terms, however the framework is, that's all fine and good, but do you have any ability to confirm that anyone's actually agreed to them? Do you track that? How do you track that when there's different versions over time?
Right.
All of these things are really important, and I've never cease to be surprised as to how many companies aren't thinking about that.
Right, and it could be that some of these are based upon what we've always had. We've had this stuff for a while, or you have consumer data that going back, and that's kind of a separate tangent issue. But you have consumer data going back for a while. Well, what did we say to them when we collected this, right? When we took in this information. So, so the next couple slides are the scare tactic aspect of our presentation. What does this look like? What could be the exposure here? There is when we were talking as a group, as panelists about, again, the sort of state privacy laws versus these lawsuits, these wiretap acts, what's the biggest driver or difference? There's a private right of action, right? Under wiretap act statutes, there's a private cause of action under, as you'll see on the next slide, consumer fraud claims, et cetera, the invasion of privacy claims, right? There's a privacy. I, as a consumer, can walk into court and sue you over the failure to get my consent to track identifying information about me when I visited your website, depending on where I live, right? Versus under the California Privacy Act and other privacy acts, there's not a private cause of action. I have to rely upon the state's AG's office to come after you, or in California, the consumer committee that's allowed to sue companies. So that's what helps here. And the other piece that helps in these lawsuits, helps the consumers, is there's a statutory amount, baked into these statutes. So it's not typically up to 50,000 per violation like you see here, although that is possible under some state statutes. It's typically, we're seeing, in these letters or in these arbitrations that are being filed, a claim for $5,000 and injunctive relief. And not just $5,000, for the one time I used it, even though I went to your website 12 times thereafter. There can be, allegations or claims around every time I went to your website and every time I did, a various, you captured data about me without my authority or my authorization ahead of time. That's a separate violation of those statutes, right? So that can really ratchet up. If I even have an individual, it's just Molly Arranz suing you, but I went to your website a dozen times, that's 60 grand a pop, right? Just for me visiting your website type of thing. So, and as we mentioned, as we've talked about, those are being potentially combined with other threats or other claims that aren't just relegated to the Wiretap Act or the eavesdropping acts in various states. It can have, consumer fraud statutes, unfair competition laws, invasion of privacy, etc. Drilling down a little bit more in terms of some of these, what do these lawsuits look like? I mean, just quickly perusing the dates, right, of some of these matters. You can see these are all just from last year, activity there. What we as panelists talked about is like, how do how do these look, right? We've talked about class actions. There's absolutely class actions out there. There's also, some of these are in arbitration, some of them are in mediation. A lot of these, just because it's a quick fix, are being resolved by trying to pay off the individual consumer to try to get rid of that one individual. But if you don't have a long-term solution in place, right, there's nothing to be said for the next person not coming after you and filing a separate lawsuit or bringing a separate claim, because you won't get full peace by paying a certain amount of money to sort of pick off the one consumer that sent you the one letter or filed the one lawsuit. So now we're to the really heart of what I think we want to talk about today. Like, what can you do, right? There's sort of this exposure out there, but what can I do as a company to potentially stave off this potential exposure or these claims, or reduce them significantly? I mean, obviously one option is don't use any tracking technologies, but I have a feeling you're going to get a lot of pushback from your business folks, your marketing folks. But I'll open it up. I guess, James, I'll start with you, because I know you've talked about contractual terms and otherwise, what would be sort of your top level recommendations around trying to avoid some significant exposure?
Sure. I think it starts first and foremost with understanding what you're using as a company, how you're gathering the information and where it is. And then that's within your own company and then within third parties that you're working with. And certainly, we've talked about, well, who should be involved? I think it should be a well-rounded team within the business enterprise, from marketing to IT to legal compliance to sales, which sort of dovetails with marketing, but not always. So understanding what you have, how you're using it, and then building out a set of terms, which you may or may not already have. And that if that's online and it's truly B2C, then you've got to be a little more careful probably and a little less one-sided to really have a chance at the terms actually being upheld. But ultimately, you've thought it through. And then at the end of the day, I think best practices in the concept of tracking itself and wiretap, allegations, to me, it just seems to fit perfectly in what we know as cookie policies, which most of the times are standalone policies that work with privacy terms, but sometimes not. And I just think it's best practices to have an opt-in approach. Consumers are pretty much, used to, the pop-ups that come up on every website nowadays, right? We all think they're ugly, but it's sort of a means to an end. So a matter of making sure that you're identifying things, you're asking for consent, and then you're tracking it so that if something does come up, you can say, look, we did this. This is when it happened, and John Doe agreed to these terms. So there you go, right? It's not a perfect world, but that's kind of where I would start with a client if they ask the question.
Man, what are your thoughts around this? Any kind of best?
I mean, it always boils down to, are you in a defensible position based upon the decisions that you're making along the way? I mean, I think we spoke a lot about what is the objective here? What do you want to do with this new technology? Do you understand the risks and benefits of the new technology? I told you we're going to try to throw AI in here somewhere. I mean, it's a similar approach to the use of AI. Do a risk-based approach. Do you really need it? Are you just trying to keep up with the Joneses? Are you going to get any benefit out of using it compared to the risks that you're taking on in using it, knowing that maybe you don't have the right personnel to monitor or to integrate it, into the current network. I mean, compatibility is huge. All right, you have to make sure that whatever tech you use and how you use it, it's compatible with your current network. It's not a bad idea if you decide to use it, taking into consideration the risks, the benefits, the personnel who are going to oversee it, to conduct a pilot program, test it out. See, I mean, that's what they're doing with the integration of AI. They're agreeing to use it after evaluating, and then they're using monitoring tools to make sure that people are using it the right way so that they can catch any type of anomalies early on, instead of waiting until you have a consumer or someone complaining. So there's a measured approach that you can take to using this. So if the decision is to use it, that would be my recommendation.
Yeah, and it's interesting because I know, right, with the sophistication of AI, be it, kind of monitoring and collecting some of these data points, possibly, and interfacing with your technologies online, do you have that as part of your privacy policy? I know our team, like your outward facing consumer policy, right? I mean, our team has talked about that. I mean, hopefully a lot of companies have at least thought about, if not put in place, internal facing policies for their employees and otherwise around AI. But what disclosures are you making in your privacy policy about, or your other outward facing policies and disclosures about AI? How transparent are you being there? Again, with an eye towards, what the law requires is one thing, certainly, but what like consumer expectation is around this may be another, right?
Well, they always, I'm sure all of us and everyone on this webinar have heard about policies, and people have called all of us, I'm sure, and said, hey, I need a policy. And then when you say about what, AI, we want to use AI. Well, that's the last thing you should be doing. Let's talk about what you've done to reach the decision to put a policy in place. And really the same applies here, maybe on a simpler level, but the same approach should be followed.
And to me, it always comes back to just data privacy norms in my view. And at the end of the day, if you're in a jurisdiction requires you to tell consumers what their rights are and tell consumers what data you have and how are you using it and so forth, then it really doesn't make a difference if it's AI or if it's tracking technology, because it involves data, right? And you have to tell and know what you're doing with the information anyway. So to me, it's a matter of, okay, what are we doing? How are we doing it? What are our vendors doing? How are they doing it? Do we have protections in place with vendors? That's certainly best practice. But at the end of the day, whether it's AI or tracking technology or some other mechanism, you as a business, you have to do your homework. You have to understand what's at play, and you have to inform consumers. And there's no way around it.
Right.
Yeah, and to sort of build off of that, James, I mean, a couple things. One, this idea that, the pop-up being something that's built in with your cookie disclosure or otherwise, but just a disclosure that is immediately when you visit a website, having that front and center, it's really, I think, going to become more of the practice du jour as this goes on, as this potential exposure builds. But having the affirmative consent to be tracked and to make that clear and conspicuous, et cetera, it's sort of going hand in hand, this is my point, with what CCPA is requiring around disclosures around sale of data. When from my experience, and I'm sure you have more experience with obviously California's law than I do, but when this whole idea that you would have to disclose your selling data, what a sale of data look like, right? In early days, that was such an awful, ugly sort of idea in many companies' minds. Like, I'm not going to tell consumers I'm quote unquote selling their data. But now I think, it really is something a lot more companies need to think about, because of the fact that it's becoming a much broader concept and also more sort of readily accepted and understood by not only consumers, but by companies, that utilizing cookies and sharing those with Meta is possibly a sale of data, right? And under CCPA alone, and likely other state statutes as well, or laws, it's going to be something where you need to disclose that and give consumers that option, right? And building that in.
Here's
And the
another
definition is so broad too. So
Yeah.
So, another best practice is to consider the internal policies that are in place with regard to the user using a company device to roam around the internet. Okay, we know there are trackers out there that are, tracking IP addresses. Are they putting your business and organization at risk by being permitted to use a company device to play around at the internet? My answer would be yes. And so I think there should be a strict policy in place that when you're on our devices, you're not going to be roaming the internet, because I think it could put the business's information at risk.
Yeah. No, it's great. I mean, you need to have outward facing policies and disclosures and inward facing ones, absolutely, to make sure you've got everything very clear.
Right.
And then, I know we've talked about this a couple of times, but just to put, again, put this in front of everyone, the terms that you're utilizing, be they terms and conditions or terms of use for your website, consider whether it makes sense to have some disclosure around, and these terms around mandatory arbitration clauses or a class action waivers. So, certainly if you've got a letter like this, one of the first questions that I know a lot of companies are asking is, could they sue us in a class action or private litigation, which is pretty dramatic exposure, or do we have a term in our terms of use on our website that requires them to bring any claims, in arbitration, private arbitration, as opposed to a class action lawsuit. And one other nugget
I think that's mandatory these days,
yeah.
Particularly if you're going to have a touch point in a state like California, as an example, you desperately want to avoid the potential of a class action. And arbitration can be quite expensive, as we all know, but it's so much less expensive, and would require then each potential party to bring the separate action, which it may seem daunting, but it's a much better scenario than potentially having. I have an example of a client, not particularly in wiretapping, but it was a data breach. It was a third party, it's a vendor, and it was a Ukrainian cyber terrorist organization, bad actor that hit them. So it wasn't even really them. I mean, gosh, poor vendor. But ultimately, there's been, I think, over 2,000, complaints filed in the United States as a result of, businesses that had no ability to protect the data that was, stolen. And so, the point being that that it's most of my instances where these things come up, it's really not my client that's ultimately done something wrong. It's usually a third party, and they may or not have done anything wrong. So just, you know, I know it's a little tangential off the topic, but it would come up in the same way as a tracking, you know, issue with if a third party is the one tracking. And the question really is to the business, you know, and to the client, do you even know what they're doing? Have you ever even had the conversation, you know, with your vendor? And I think most of the time, the answer would be no. So best practice is have the conversation, have it frequently. You know, they're coming to you and they're asking for more money on an annual or however long basis, right? So that's your touch point. So what, you know, get updates from the vendor and look at the contract, and maybe we need to make updates. You know, ultimately that's going to be, because if you get a complaint against you or your client, you're going to be able to show that you acted reasonably, you weren't negligent, you know, cared about security and data privacy, you update your policies, you know where the data is, et cetera, et cetera.
Yeah, it's that holistic approach again. And really, when you think about it, there's a common thread between, you know, cyber risk, resiliency, AI governance, you know, cookies, tracking, you use the tracking mechanisms. I mean, there's a standard approach that you take, and it boils down to holistic and understanding the tech and transferring the risk.
Vendor management. Yeah, I mean, I will say one more thing too before we leave the terms point. And James, it sounds like I kind of know the answer, so I was going to ask you this, but you know, I know for us with advising clients around mandatory arbitration clauses and class action waivers, at least with the consumer facing potential exposure, you know, there would be some clients who are like, I don't like how that looks, right? Because you have to make very specific and all caps, you know, statements around mandatory arbitration. But I'm finding more and more that companies are, you know, when faced with something like this, right, are okay with it. Like they don't feel like it looks as bad now, much like the do not sell button, right? They're not feeling as bad about having that, even if there's a gray area or they can make a choice between a mandatory arbitration clause, for example, or not. We're seeing more of that happening. Is that kind of similar, James, I guess, to what you're experiencing in terms of those, you know, disclosures or statements by your clients?
Yeah, the comfort level within the business community in general with respect to having robust privacy policies and so forth has shifted, you know, in a massive way in the last, say, 5 years, right? I mean, you know, for the most part, unless you were a gigantic organization, if even a handful of years ago, you thought about this kind of stuff, but you never really put it in your budget, and you know, you weren't swayed by my, you know, persuasive arguments as to why you should take it seriously. And I think now that's shifted, you know, clearly shifted. And I think companies of all sizes, the startups I work with, are still very much concerned about it. It's just a matter of, you know, ultimately it's budget and other things, and they're trying to build out, you know, products and so forth. And I get it, but you know, the last thing you want is to build out this wonderful thing in the startup stage and then have it be attacked, you know, almost immediately because you just didn't think about something simple, like a term in the policy or how the policy was presented and getting consent ahead of time, et cetera.
Yeah. Before we leave this, because I don't want to not mention this in terms of what can a company do, a really easy lift for anybody that's watching this or joined us here today is to consider whether or not your website has a chat bot. If I can go to your website and there's a little, you know, window or question mark or whatever, and or it pops up automatically, and I can go online and interact with your, again, AI, Karen, probably an AI chatbot, right? And talk to it back and forth about questions I have on your website or whatever. You need to have some sort of disclosure around the fact that this conversation is being recorded. Again, the technology is likely behind it. That's a lot of how this works in terms of these chatbots that are on there that are very helpful. And I would also recommend a link to your privacy policy. This is a very quick fix, but similarly, a lot of our clients, well, not a lot, hopefully, a few of our clients are getting letters around that as well. That, you know, if they utilize a chatbot, you know, they may be getting, you know, a letter, a nasty gram letter from a consumer saying, hey, I went and used your chatbot. I didn't enter personal information, or maybe I put my phone number in there and I put my name. But you didn't tell me that it was going to potentially be recorded. And in a very loose interpretation, again, of these wiretap acts and otherwise, that can be considered to be a recording of a personal information.
We do have a question, as you're talking about websites that came in. The question is, how can I find a good cookie interface for my website?
So there are vendors out there. I don't know if this is kind of the question. There are vendors out there, and actually our team has actually looked into a couple options, but you can absolutely get assistance from outside vendors to really manage this, unless you have a robust internal like marketing team to figure out, you know, the levers, the toggles to put on and off to help manage that. A lot of the time though, if you don't have the internal capabilities, you have to look to an outside vendor to help with the management of, you know, that interfacing and what's actually being collected to help shore up, really frankly, your disclosures. Again, this is, even though there's been quite a bit of like claims around tracking technologies to date, a lot of them were more geared towards the big, you know, Google, Meta, et cetera. Then healthcare providers were being targeted, frankly, in terms of utilizing tracking technologies on their websites. We're seeing a build up from that. So this is still a little bit in its infancy with regard to just everyday standard sort of consumer websites, but in terms of like looking at how you can best manage this and attack this and see how it's all working together, it may be best to look to somebody who has the savvy, a vendor or internally, to look at those tags, pixels, and cookies.
Yeah, there's a lot of companies out there that do this kind of work, and sometimes the provider that's managing the website itself has plugins as well. So it's not quite as daunting as you might think to get it up and running.
Yeah.
As long as you're educated on what you're doing so that you have the right questions to ask.
Right, exactly. It's really manageable if you don't approach this as like a tech talk or, you know, something it is accessible. It's, you know, it can be explained in a very like accessible way. Hopefully we've done some of that today, but certainly in terms of looking at your own private website as well. So as we're kind of approaching the hour here at the end of our presentation or discussion, we wanted to put up, you know, just in thinking about data privacy, right, and cybersecurity with the new administration and then in 2025, and to reemphasize this idea that what are consumers, you know, thinking about and what's top of mind. You know, even President Trump in March of 2025, you know, was noting that consumer rights are a cornerstone of American freedom, et cetera, and that the administration, in thinking about this, is committed to protecting the American consumer, upholding the right to privacy and transparency. So even though there may be some downsizing of some of the federal, you know, arm of this, and maybe some of the federal enforcement of these concerns, regulations, statutes, et cetera, you know, this idea of transparency, consumer transparency, is still top of mind and a top priority. Even if, again, the government wasn't pursuing this, the attorneys general were not pursuing this, there's absolutely private litigants out there, certainly plaintiffs' counsel, who are keeping this top of mind, primarily, if not solely, because there's these statutory amounts associated with these sorts of claims, right? It gives them a great argument to make that if they can piece together hundreds, thousands, tens of thousands of individuals who had the same potential invasion of their privacy or violation of a wiretap act, you know, at $1,000, $5,000, $10,000 a pop, you know, you can do the math. That adds up quickly. So
I think what you mentioned earlier, Molly, with regard to fines was great, but keep in mind it's the company's reputation, its downtime responding to these complaints. So it's certainly something that you want to try to avoid at all costs.
Not to mention legal fees, right?
Right,
Good for us, but not good for businesses.
Yeah, exactly. And there are some statutes and some, you know, consumer fraud statutes or otherwise where there could be a recovery of attorney's fees, right, too. So that's an added motivator to bring these matters. We're at the hour. Do you guys have any sort of final thoughts or suggestions or if not, we obviously have our, at least, I didn't put our emails up there, but we have our names up there if you've forgotten them, and certainly can answer questions offline as well.
Absolutely. Yeah, it's been a pleasure, and I'm always available if anyone needs anything.
Thanks for everyone's time. It's an important topic to discuss.
Great. Well, thank you, Molly, Karen, and James, and thank you to everyone for participating in today's webinar. If you'd like to participate in any future roundtables or webinars, please see the link in the upcoming event schedule that I've posted in the chat. And as our panelists mentioned, if you have any questions, please feel free to reach out to them or any of the US Law staff, and we will pass them along. Thank you.
Thanks.
Thank
Bye,
you.
everyone.
Bye-bye.